case briefs, and so much more. LSData's got what you're looking for.
In 1960, the District of Columbia Municipal Court of Appeals heard a unique case involving the Cleveland Park Club and a 9-year-old boy. The case explored the delicate legal boundary of childhood recklessness and established intentions to cause harm. The lawsuit was triggered when the child, acting either out of innocent curiosity or intended mischief, inserted a tennis ball into a noticeable pipe located at the bottom of the club's swimming pool. This seemingly innocuous act led to significant damage, resulting in the pool's closure for required repairs. Stepping into the courtroom, the Cleveland Park Club sought financial restitution from the child who caused this upheaval. Their lawsuit argued that the boy was aware of his actions and thus was trespassing with an intention to do harm. However, the child's counsel proposed a counter-narrative, suggesting that due sheer negligence, club's lifeguards failed to prevent the incident. They also stressed that the boy's age should be taken into account since it might inhibit full comprehension of the consequences of his actions. The jury received directives to pay close attention to whether the boy could be categorized as a trespasser and whether the club had unwittingly consented to the act through their lack of preventative measures. The court initially denied the club's motion for an immediately directed verdict, deciding that the child's age and the potential role of the club in preventing the incident held substantial relevance. Despite these considerations, the court ultimately decided to reverse the case for further proceedings. In the retrial, it was determined that only the issue of consent from the club would be the focus, while all other topics pre-decided and approved. This institution of a second trial acknowledged the potential ambiguity and error in the initial trial's jury instruction. It decisively concluded that the child's actions were clear and intentional, creating a precedent that a child's age does not necessarily exclude them from legal responsibility. Unfortunately, Chief Judge Rover, author of the opinion, passed away before its publication.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.